And now I'd like to welcome our guests, Jeffrey Minear, counselor to the Chief Justice of John G. Roberts Jr., until very recently, I'm told maybe 11 days ago. Right. Still counting in days. You'll get over that. And the Honorable Jeffrey Sutton, Chief Judge of the U.S. Court of Appeals for the Sixth Circuit. I'll briefly tell you a little bit about each of them. First, Jeffrey Minear retired from public office in September after more than 4 decades of federal service to the Supreme Court and the U.S. Department of Justice. At DOJ's Office of Solicitor General, Mr. Minear argued 56 cases before the Supreme Court. Where do you rank, do you know? That sounds pretty high.
I've fallen behind. I've been out of service.
Is it like the video game boards where you enter your initials and you're up there? I bet you're up there. In 2006, Chief Justice Roberts appointed Mr. Minear as counselor. The counselor is charged by statute with performing such duties as may be assigned to him by the Chief Justice. He serves as the Chief Justice's Chief of Staff and advisor. And Mr. Minear served at the court for 16 years, a record tenure in that office. In that role, he worked closely with court officers on court-wide policies and initiatives. Mr. Minear also supported the Chief Justice as the head of the federal judiciary. He worked in partnership with court executives and judges on matters of judicial administration. He also served as liaison to the executive and legislative branches on issues affecting the courts. Additionally, Mr. Minear represented the Chief Justice in relations with judicial organizations, foreign courts, and visiting dignitaries, and served as the executive director of the Supreme Court Fellows Program. He also supported the Chief Justice in his non-judicial responsibilities, including as Chancellor of the Smithsonian Institution. And perhaps most importantly, Mr. Minear is a 1982 graduate of Michigan Law School. Chief Judge Jeffrey F. Sutton is the Chief Judge of the U.S. Court of Appeals for the Sixth Circuit. He has served as the chair of the Federal Judicial Conference Committee on Rules of Practice and Procedure and is chair of the Advisory Committee on Appellate Rules. He currently serves on the Executive Committee of the Judicial Conference of the United States and as the commissioner of the Supreme Court Fellows Program. I see some overlap there. Since 1993, Chief Judge Sutton has been an adjunct professor at The Ohio State University College of Law, where he teaches seminars on state constitutional law, the U.S. Supreme Court, and appellate advocacy. He also teaches a class on state constitutional law at Harvard Law School. Heard of it. His publications include Who Decides? States as Laboratories of Constitutional Experimentation, and casebooks on constitutional law and judicial precedent. In 2006, Chief Judge Sutton was elected to the American Law Institute, and in 2017, he was elected to its council. Mr. Minear and Chief Judge Sutton, thank you so much for being here today. We look forward to hearing your thoughts about the constitutional roles and responsibility of federal courts to American government and our democratic institutions. I regret that I'm not able to stay for the entire conversation because I have a class to teach, but when I leave, rest assured I am not storming out in protest. So let's please give a warm round of applause and a warm Michigan welcome to Jeffrey Minear and Chief Judge Jeffrey Sutton.
Thank you, Professor McQuaid, for that warm introduction. Thank you to Michigan and the Big Ten for hosting us. Thank you, Jeff, for including me in this conversation. We've got some questions here. We're going to go through our script a little bit, but if past is precedent, we'll probably ultimately have a conversation where we largely agree, but maybe disagree about a few things. We'll see. So let me get the ball rolling here. And so the conference is Democracy in the 21st Century. The obvious question is, how does an unelected, politically unaccountable judiciary have anything to do with promoting or facilitating democracy?
Let me begin, first of all, by thanking Professor McQuaid, Professor Newbold, Professor Carver, and the other people who have organized this event. It's really great to be doing this with Chief Judge Sutton. As to your question, I think it really reflects the genius of our framers. They were naturally skeptical of a national government, and they recognized that even a democratically elected Congress and a democratically elected president could engage in excess. And they formulated the idea of a judiciary to basically establish the guardrails to police those excesses. And in that sense, the court has been very effective in promoting democracy by ensuring that even though it has a counter-majoritarian aspect to it, it ensures that those two branches stay within the rule of law. And I think it's really quite remarkable that the framers actually had that insight and have, created a judicial branch that has had that effect throughout history. So I think, as Justice Breyer would say, that the role of the Supreme Court and the lower courts is to keep both the legislative branch and the executive branch in their lanes and make sure that they do not, by dint of popular appeal, exceed what their lawful authorities are under the Constitution.
Yeah, I mean, one feature of this question is, when we started having judges at the outset, they were all selected, nominated, but all for terms. There was no life tenure. And so the state courts all had these terms. And, one of the things that's always puzzled me is, how did we get life tenure? I mean, that's such an astonishing thing. Even in a world where people are living just to 50, 60 years old, why life tenure? Well, one reason was Rhode Island had this really interesting case. It was a fight over debtors and creditors, but the gist of it is that the state court judges in Rhode Island invalidated this legislation that the Rhode Island legislature had enacted to protect debtors, I think is the way it worked. Well, the legislature was not happy with this. There were 5 judges, if I remember, on the Rhode Island Supreme Court at the time, and they called them to account. They called all 5 judges to come to a session of the legislature and explain themselves. Like, how could you possibly think you could invalidate this? 4 of the 5 showed up. The 5th said he had a conflict. Remember the 5th. The 4 go, they try to explain what they've done. The legislature is deeply unhappy with what's happened. They ultimately decide not to impeach them, but they're 1-year terms, so they don't reappoint them the next time. The only judge that survived was the one that didn't show up. So, if you're wondering, don't go to those meetings if you can avoid it. Hamilton, so the account of this case was written about widely. Hamilton saw it, and so it's one of the reasons that they decided, we can't have terms, because look what happens. The legislature will just punish everybody that does the right thing. Everybody that keeps, the legislature in its lane will lose their job, and hence we won't have an independent judiciary. Now, whether they should have said, 1-year terms are bad, life tenure is what we need, is, perhaps another question. As it turns out, fast forward to today, we have 51 high courts. We just have 2 with life tenure, Rhode Island and the United States. So everybody else has either age limits, term limits, or some form of election accountability. So
that's reflected internationally. I don't think there is a single major country that has life tenure. It's quite unique to our system. But we can return to that tenure question later.
Or after I retire, but keep going. Yeah.
But going back to the framers, obviously the people like Madison and Hamilton had a conception of what the courts should be doing. Do you think today that they're doing what Hamilton and Madison and others expected?
Well, it's hard to know. My instinct is they'd be quite surprised. They famously thought it was the least dangerous branch, and in some respects it, of course, was. No power of the purse, no power of the sword. But it is, I find it quite striking, the role the federal courts in particular play in American government. And, judicial review gets its start in 1803 by Marbury versus Madison, at least on the federal side. And it's not an immediate growth industry. In fact, you'd say for the first 100, 150 years, there really aren't a lot of cases where the court is exercising that power. But, really from about the 40s on, it's really got this really significant role in American government. And to me, this is more question than answer. If a goal of the setup was to have these 3 branches, each checking the other, to use your phrase, the judiciary would keep the executive branch and the legislature in their lanes, we should remember that the phrase was not just checks, it was checks and balance. And I have to wonder whether the framers would think that maybe there's a little imbalance now, that the federal court role is a little outsized. And one of the things that's very tricky is how do you check the court? A traditional way to check a court in performing, constitutional judicial review is to overrule its decision. And a way to overrule a court decision would be to amend the Constitution that they're interpreting, right? They say the Constitution means X. The people sit back. They say, we don't think so, and they pass a constitutional amendment. I did this exercise once before. I think there's only 8 constitutional amendments that actually overrule U.S. Supreme Court decisions in all of American history. I mean, the most famous is Chisholm and the 11th Amendment. So it kind of looks like they're going to go down that road. But it's only 8 in history. And, as a federal judge, I'm a proud person. But did we only make 8 mistakes in almost 250 years? Probably not. And part of that goes to the point that it's very hard to amend the Constitution with 3/4 of the states. So I do wonder, whenever you're trying to fix problems or, in this case, set up a blueprint for government, you're focused on the immediacy. And so an immediate problem would be Rhode Island. We can't have 1-year terms. It's got to be longer, so they go to life tenure. The Articles of Confederation, if you wanted to change the Articles of Confederation, you had to get 100% buy-in. So every state had to agree before you could amend it. And so they thought they were actually being quite flexible and reasonable. 3/4, that's a big drop. And, maybe that was a little hard, but in terms of giving the people an option of disagreeing with U.S. Supreme Court decisions. But I guess my fundamental answer to you is it's hard to imagine they would be comfortable with the role of the court today.
Yeah, I think that's certainly the case. If you look to the first Chief Justice, John Jay, he retired after 5 years because he thought the Supreme Court would never amount to anything. And the only significant case that was decided during his tenure was Chisholm, and that was promptly overruled by a constitutional amendment.
What kind of a job is this?
And it took a personality like John Marshall to actually, I think, turn the Supreme Court into the influential body that it is today. And there was a significant period in which the court was far less influential. Certainly after the Civil War, the court was really quite moribund in terms of the importance of its decisions. And I think an important part of that was that it felt it had to decide every case that came before it. And there was the right of direct appeal among for any federal case. And so they soon got bogged down in far too many cases that were inconsequential. But it does bring up a point that Judge Sutton and I have talked that distinguishes the courts from the political branches. The courts have to decide those issues that come before them, particularly the lower courts. And even the Supreme Court, as a practical matter, has to if there's a conflict among the lower courts. Congress and the executive, if an issue is difficult, they simply can ignore it and not address it. Unless there's sufficient popular will to force them to act, it's very easy for them to avoid acting on a matter. I think also there is the time dimension difference as well. That living in Washington, it seems to me the city works by and large in most quarters on a 2, 4, or 6-year schedule. It's driven by elections. The Supreme Court and the lower courts are the only courts that are really looking far back in history, following precedent, and thinking very hard about what their decisions will lead to 10, 15, 50, 100 years down the road. I mean, I can assure you a justice who's putting pen to paper is choosing his or her words carefully because they know that opinion will be read 50 years from now, just as they read opinions as well. And those dimensions really make the court a different animal from the political branches.
Well, I really want to emphasize this point that the court, Congress and the president have the privilege of not deciding, and the court rarely has the privilege of not deciding. So it creates this inherent bias that the court's going to get more and more engaged in American government. And, you can come up with doctrines like the political question doctrine, lack of standing. Those are gatekeeping approaches to this. But I do think, I think you could have a court where all 9 members agreed that the policy footprint of the U.S. Supreme Court was too large in American government and still have a difficult time shrinking it. I think it's not easy to do. One of the things about the Marshall Court, when the power of the court grows, most of those cases are not invalidating things. Most of the cases are permitting the national government to do things. I mean, so a lot of the expansion of the national government does come because the court is actually being democratic. It's letting these democratically enacted laws get passed, and they tend to expand the national government's authority, and then it raises the stakes the next time. And I mean, it's amazing how many of the cases the last decade or so at the U.S. Supreme Court have been cases that are really created by Congress not acting. I mean, most people would have preferred them to enter into the fray about how to deal with this clean water issue, this clean air issue, this pork production issue. But if you have a Congress that's not doing it, people that care about these things are not going to sit by. It's quite natural to go to court, and the federal courts are open, and so it's what happens. So Jeff, the framers debated the benefits and dangers of a national government. Madison believed that it would facilitate democracy by diluting the effect of faction, and the Anti-Federalists feared it would overpower the states as the engines of democracy. What role have the courts played in advancing Madison's hopes and realizing the Anti-Federalist fears?
I think the court has done both, quite frankly. First, as you've just pointed out, the court, particularly during the Marshall era, was responsible for enlarging the scope of the national government. That was not, certainly I don't believe the framers expected that expansion that did take place. And in that way, they, in fact, realized some of the anti-federalist fears, that this national government was going to overtake and superintend the states to a significant degree. In terms of controlling faction, I think the court has been somewhat successful on that. I mean, of course, Madison's great contribution to political theory was that the larger the expanse of a democratic organization, the less likely there will be faction, because the national interests will start to overtake the local interests. And I think the court has, some of its decisions reflect that. I think Brown v. Board is a good example. I don't think you could have had a state-by-state solution to the problem of Jim Crow. It really required a national government to address that in a national sense. And in this particular case, the Supreme Court took the lead. But there are some issues in our national polity that require a national response. And so I think the court's intrusion into these issues has in fact benefited the resolution of them as well. But then that, I think, raises the issue of what about the states? And I know Chief Judge Sutton has thought about this a lot and written quite a bit about it. How do you see the relationship of the federal courts and the states with regard to democratic principles?
Yes, a bit of a hobby horse. You could argue that that's the most important question in American government. What should be national, what should be local, and that's what we should be debating much more often than we do. And I think I would say there are different times in American history where the national answer is the better answer. Think dealing with the Depression, think dealing with Jim Crow, and I think with other issues, it's really wonderful that we've got this federalist system where different states, different regions can try different things. You know, one of the features that comparing the two constitutions or two sets of constitutions that really surprised me was realizing how stuck the national constitution, the national structure of government is in the 18th century, and how the state models have just been so transformed in this almost 250 years. And there's a good explanation, and then what's interesting is what it does for us. The explanation is that the state constitutions are super easy to amend. It just takes 51% vote. And so if the people want something, it's real easy for a majority to change the Constitution to deal with something they care about. And the federal Constitution, quite famously, is stuck in this. I mean, stuck sounds like I'm giving it a normative, pro or con. I don't mean that, but it's just very 18th century. Whether you want to focus on the Electoral College, 2 senators per state, judicial review in its largest manifestations, I would say is not democratic at all. Whereas on the state side, they just get more and more hyper-democratic throughout American history. It's so astonishing. They first decide after Jacksonian populism, hey, this election stuff is great. Why are we just voting for one governor? Why not vote for everybody in the executive branch? Let's vote for AGs, governors, secretaries of states, superintendents of insurance. It's astonishing what you can vote for in the executive branch. Then, of all things, Mississippi and New York, how many times have Mississippi and New York led the charge on anything? Mississippi and New York lead the charge on election of judges. That is transformative to say that judges can be elected. That's 90% of state court judges after that have some form of electoral accountability. Then the progressive era, the initiative, fully half the states have some form of direct democracy where the people can say to a statute, we don't think so, and correct it themselves. And 18, 19 states, depending on you count, can amend their state constitution on their own, which has really made a huge difference. So it's so strange to me. I mean, think of it this way. The people of Mississippi, New York, Ohio, California, and Colorado have more in common with respect to what they want in their constitution than they do with respect to what's in the national constitution. You would have thought if the people from those disparate states all wanted the same thing, you would nationalize it, right? It's such a, big cross section of the country. Well, it just hasn't happened, presumably because the national constitution's so hard to amend, partly because maybe, we love the Madison view of venerability and not too many amendments. But I really, that feature of federal versus state constitutions has me thinking one thing we could do that might shrink the footprint of the federal courts is maybe think of how using the state courts as more in the vanguard, more of the first responders when it comes to new challenges to liberty, property, equality, you name it, because the stakes are so much lower, right? I mean, if the state courts get too far in front of the people have serious correction mechanisms, replace the judge, amend the Constitution, direct democracy, you name it. And I will say the last 75 years of American history, we really have more of a top-down approach where it seems the national Supreme Court tends to be the first one to do the innovation and the states more following. And, I have to wonder if that's good. I mean, with legislation, we're pretty comfortable with letting the states take the initial lead if it's a difficult problem and, you want to let them be the classic laboratories that Brandeis referred to. If we're comfortable with that in America circa 2022, why shouldn't we be comfortable with letting the state courts be the first innovators when it comes to new constitutional rights, new challenges to privacy, or whatever the problem might be? So, I will say this, I don't think the U.S. Supreme Court's responsible for sidelining the state courts. I actually think we Americans are responsible. If there is a problem, I think it's we Americans who are responsible for it. We've come to love the story of the U.S. Supreme Court nationalizing these rights because, sometimes they're heroic. See Brown ending, bringing Jim Crow to heel. That's a heroic story. And so we kind of want to repeat that story. The problem is, the U.S. Supreme Court, they're not always right. For every Brown, you have a Buck versus Bell. So, but I do think we Americans have come to ask the court to give us what they've been giving us. We like a national court that has these debates. And so I don't blame the justices or federal judges for that matter. I think it's something we Americans want more than we maybe should.
Just a footnote on that. In Europe, they have a principle in there that governs the European Court of Justice, and that's the principle of subsidiarity. And the notion here is that issues should always be resolved at the lowest level of government that can competently handle it. And it is really reflected in their decisions that they expect those decisions to be made. Any decision that can be made at the local level should be, and only the matters that require a national attention should be made nationally. And it's something that I think is necessary in a confederation as loose as the European Union, because obviously they do not have the unity of purpose that the United States has, given the number of different of nations that are incorporated through the Union. But it is a valuable lesson from overseas.
Well, and that lesson applies. It's another thing that's going on politically in the country is, we have this phenomenon of red, blue states, and of course they change. Think West Virginia or Utah. But then the other feature going on is within states, it's not too gross a generalization to say that within a lot of states, some of the cities are getting bluer, more progressive, whereas the rural areas and some of the suburbs, red or more conservative. And the way that cashes out in a lot of states is you have more conservative state legislatures, more progressive cities. And I've wondered why we can't kind of have a federalism within federalism. I mean, to take my state of Ohio, why does the Ohio legislature need to control everything Cleveland does? I mean, why shouldn't Cleveland have some of this authority to figure out exactly how these local issues should be resolved? So it's not just national versus state. It also can work quite productively, state legislature versus local government. So Jeff, you've the last, I don't know if it's 6 months, or I don't read these stories as closely as I should, but I've seen enough stories where the word legitimacy can be found within 10 words of the U.S. Supreme Court. And what should we make of these? I mean, you've spent 16 years as the counselor of the Chief Justice at the middle of the highest court in the land. I'm an inferior, never cared for that term, inferior lower court federal judge, but still, I may be in the farm team, but it's still the same game and the same team. We're judges. So when I see legitimacy in federal courts, I do have a slightly instinctive negative reaction. But what should we make of it, and do judges have a role to play in responding to those articles, those concerns, or how should we think about it?
Well, I think we should be careful in using the term legitimacy in the context in which I've seen it used. To my mind, legitimacy connotes the fact that it is a valid court, that there's a quorum, the members are lawfully appointed.
There's not an inferior court judge on the case.
Yeah, and that's important, particularly when you deal in the foreign context, where there are clearly illegitimate courts around the world. The issue I think that's more difficult right now is the question of public confidence in the institution. And this has several different dimensions. For the general population, I think that they have confidence in the court based largely on whether they agree with its result. They don't read the opinions. And their view of the court is focused on, I like what the court is doing here, or I don't, be it choose your hot button social issue. I think particularly for lawyers and serious students of political science, it's important to read the opinions and analyze the court on whether it's doing its job and explaining the reason why it's doing what it's doing. And that is, I think people would have higher confidence in the court overall if they read the opinions and saw how the justices are grappling with these issues. And any of the issues, the public has focused, the media has focused really on 5 out of 70 cases, I think, that have actually gotten significant press. And they talk about it primarily in terms of the result. But in each of those cases, if you read through the opinions, you'll see there are very legitimate arguments on both sides. These are not easy matters. And I think the public would have greater confidence if they had time to actually see the analysis that's taking place and the fact that we have very capable individuals that are dealing with very difficult issues. And they recognize that. I think they all recognize that they're acting in good faith in terms of how they think the Constitution, and these are mostly constitutional cases, how the Constitution ought to be interpreted. But I think legitimacy is the wrong way to look at it. It is important for the court to have the confidence of the public, but I think that the way that confidence is maintained is by people having a better understanding of how the court is deciding the cases and its rationale, not just the result.
Yeah, I mean, another way to put it is sometimes the court is performing at its best and most admirably when they do something that's deeply unpopular. You can imagine a horrific murder where the court decides that the Fourth Amendment prohibits the evidence from being used, or a terrorist case where the alleged terrorist gets this protection under the Constitution. Those would be deeply unpopular decisions. They would lead to public approval polls going down, and that can't be the right measure for the health of the court or legitimacy of the court. I do think there's another feature of this that you can't measure today, and that's why it's premature. But I do think it's fair. And one of the things going on is the concern that the membership on the court affects the decisions. And there's certainly cases where you can say to yourself, okay, if you flip out this justice for that justice, different outcome. And I think what's challenging for judges about this is, no one likes that. We want the rule of law to be depersonalized, objective, and something that, you can feel comfortable that these 9 people at the U.S. Supreme Court, 3 people at the Court of Appeals are doing in this neutral way. And to me, even in the settings where you find yourself wondering about a given case, that particular case might have come out differently if you switch out these justices. Fair enough. Not going to object to that conclusion. I don't think that proves illegitimacy. I don't think that proves a problem with the rule of law. I think it proves you want to look at what's going on with that court over time. And I do think it's fairer over 5-10 years to measure a court that says it's doing something in a certain way. There's usually saying we're trying to do it in a neutral, principled way, and whether that's actually what shows up. I think the other thing that is clearly going on is we just have a court with a majority of justices who use different methods of interpretation. And while it's easy to understand why Americans might not care for that in some settings because of outcomes they don't care for, I'm not sure over the big sweep of things it's such a terrible idea to allow a new group of justices with a new proposed theory for doing their job try it and see how it works. In other words, if you have a warrant court that tries one approach, you can have another court that tries another approach and test it. Like over time, does it prove to work in a positive way? Does it get the what should be national, what should be local answers done correctly? So I agree with you fundamentally. The first point is the most important. Legitimacy really only goes to whether the people that were permissibly put there are doing the job that is expected. But I do think what's going on is a broader point for some people, and that is, and I think as a judge, that's the thing that's hardest. We don't want change in composition on any court to necessarily change what the Constitution means. There's something about that that's uncomfortable in either direction, whether it's more liberal or more conservative justices, which is exactly why I've got the Harvey horse that maybe the federal court's doing way too much. If we can't figure out a way to do this where that doesn't happen, maybe we shouldn't be doing so much, because that's not good for the rule of law over the long term, not over the short term.
To your point about popularity cannot be the measure, I'm, I think, one of the few people in this room that's old enough to remember the impeach Earl Warren posters that were prevalent in the early 60s. And I wasn't in the Deep South. I was growing up in Nebraska. And I think an opinion that today we all agree was an important and essential opinion in our history was an opinion that was widely scorned by a significant portion of the population. And so popularity just can't be the measure. In terms of the membership of the court, I think it's interesting to contrast today's court with the court of Roosevelt, Franklin Delano Roosevelt. As you all know, during the New Deal period, he was trying to push through an economic reform agenda. He was facing difficulties with the court that was in place when he was elected. He had a number of appointments, and in each case, the appointments he made were appointments clearly were politically motivated. They were people who would support his economic agenda. But there were people who did not share any common ideology and had very little judicial background. We had Black, who was a senator, right? Douglas, who was a SEC commissioner and Maverick. Frankfurter, professor from Harvard. Jackson, who was just a good lawyer, a good, essentially small-town lawyer till he came to Washington. They did not share any common judicial philosophy. Some of them may not even have had a judicial philosophy before they came on the bench. Yet that was the Supreme Court that we had. It would seem a far more political court than the court that we've had for the past 20 years, where virtually every one of the justices has had substantial judicial service before coming on the court. They're all people who learned, and you call it the farm team, but the essential courts are essential federal courts. If anything, we have a less political court in that sense than we have had any time in history.
I mean, isn't that interesting that it's the time where there's a charge of politicization, and I couldn't agree with you more. I mean, they've got these. Now, maybe we're going to find these methods of interpretation have been oversold, and they don't deliver on what the judges and justice claim they should deliver. But the whole point of having methods of interpretation is to say there's a way I'm doing this that has nothing to do with whether I like the outcome or not. I mean, that's the part of judging where we get uncomfortable, where the fear is that what the judges are doing under the rule of law, interpreting the Constitution, is simply a cover for getting outcomes they like. I mean, that really is the antithesis of the rule of law. And I think it's going to be super interesting to see how this works out. Does it turn out? I mean, we kind of think now of formal, informal, originalist, living constitutionalist, fixed, fluid. I wonder if we're going to think of as two methods in 5 years. So that's possibility one. I wonder if we're going to realize they're not dichotomies, that for the most part the justices are speaking the same language usually, and there are just a couple times where they make exceptions. I mean, you've had a front row seat for the last 16 years. Do you think the growth, I mean, Scalia has a lot to do with it, the growth of methods of interpreting the Constitution? I mean, you know, a lot of lay people never went to law school, know what an originalist is. I mean, I find that horrifying. Like, what's wrong with you? Are you not focusing on, like, reading good books and, you know, watching the football game? You know what an originalist is? Holy cow. Is that good, or are we now politicizing methods of interpretation? I can't figure out where this is going to end.
Well, let me begin answering that by saying, yes, I've had a good seat to watch this debate, but Judge Sutton is actually involved in it. He is applying rules of interpretation to real cases, and that makes a real difference. So I am only offering an observation like any of you can make about this. But I think there has been, and I think that Justice Scalia is really an important component of this, an attempt to regularize the idea of neutral principles. And that's where textualism comes from. That's where originalism really comes from. I think it goes all the way back to Herbert Wechsler. And what are our neutral principles of adjudication? I think we're seeing that even in originalism and textualism, we're having the same problems that we had before with resort to legislative history. The opinions this term have been very heavy on looking at historical research to try and reach a conclusion. And people choose their historians now, just like they used to choose their committee members. And so it's not clear to me that, I think this is an important issue, because the way we build confidence in the public is by demonstrating that judges are acting acting as judges, using neutral principles, favoring neither the rich nor the poor, providing equal justice to all, and it has to be demonstrable. But even ideas such as originalism and textualism still have their difficulties in this area. It's still, a problem of how do we make sure that we are removing personal bias or personal predilections from the decision-making process.
Yeah, a great illustration of that. I realize we have lawyers and non-lawyers participating, but a lot of people have heard of this case. The case was Bostock, and the question was whether Title VII's reference to sex covered classifications based on gender or sexual orientation. And there are three separate opinions, all going every which way, written by three textualists. So three textualists disagreed quite firmly about how to handle that case. And I think it confirms your point that even a court would I think these labels are quite dangerous and misleading, but even if we assume it's a court with 6, quote, so-called textualists, doesn't prove you're going to get consensus. Frank Easterbrook gave a graduation speech at Swarthmore, the poor kids that had to suffer through this. But his graduation speech was on con law, so I don't know what the physics majors were doing during this speech, but he made this very good point, was you could put 9 clones on the U.S. Supreme Court, and I promise you they would eventually disagree. That happened with FDR. You had 9 people, 8 of 9, all of the same worldview politically, and they ultimately ended up disagreeing. The Scorpions, that's Noah Feldman's book about that court. And it'll be interesting to see. I mean, the one thing I might say to give a little defense to originalism is to say, one way to handle it and deal with this very serious risk that you're going to see what you want to see in the history, right? So that's the risk. The same thing that happens with interpreting the statute and looking committee reports. You see what you want to see and you give it more dignity than it deserves. I do quite agree. There's a similar risk with history, and maybe the risk is greater because it's the 18th century, so this language and these concepts are much more dated. But it does seem to me there's an out, and the out for me is if it's not clear what the text and the history show, then it's for democracy. And, I think that's what led to McCulloch and the upholding of the Second National Bank. And I think that is a one out on this problem. But the thing that I guess you could say is nice about having 6 justices that claim to embrace the same method of interpretation is time's going to show whether it can be done in a principled way. I mean, you can't. It's really a nice feature of judging that we're forced to explain our opinion, explain our vote through an opinion. So that's the initial thing we have to do. Then over time, the people get to see whether we stand by it, or are we bobbing and weaving in convenient ways. And you really can't hide from that assessment. And I think that's very healthy. And I think it's good for the justices. It's good for lower court judges. And it'll be interesting to see. But I do think there is one out here, and the out is simply to say if the text and history don't help you clearly show that the Constitution applies, then it's up to democracy, and that's not the worst of all worlds.
I'd make one small addendum to that.
You're going to disagree with me?
Only in this sense that I think that when you're uncertain about the result, it's also important not to decide more than needs to be decided. And in recent years, the statement that Learned Hand made about the spirit of liberty is the spirit of not being too sure you're right has certainly resonated with me more. And as I get older, that is all the more true. But I think that is also an important break on the judiciary that can instill confidence, is not deciding more than has to be decided.
Yeah, and we can throw out the term restraint. We won't use the term restraint. But what we will say is don't do more than is necessary. And if you're constitutionalizing something, you have to remember the people basically can't correct it if you're wrong, and they can't replace you if they're very agitated by your vote. So mindset might be more important than some label like restraint. Well, Jeff, you before you became counselor, so you've had this front row seat for 16 years. Right next to the chief, literally helping him run Article 3. But you also argued almost 60 cases at the court. Were there any at the court where so I'm sure some of those were high-profile cases. I know you did a lot of environmental cases, original actions. Did that give you confidence that the court could be trusted to do rule of law, constitutional interpretation in a way that was neutral and not simply driven by this agenda or that agenda?
Well, I guess one story from early in my days in the SG's office, when you're new in the Solicitor General's office, which is the office within the Justice Department that's responsible for Supreme Court litigation, your first case before the court is always a case that is either a sure winner or a sure loser. And I had the good fortune of drawing a sure winner in my case. But one of my colleagues...
Did you win it?
Yes.
Okay, good.
Yes,
good,
it was.
Just want to get that off the table quickly.
But one of my colleagues drew a case that was clearly it was a takings case from the state of Hawaii. And it was a case in which you might...
I do know
you know what it... You probably recognize it. But it was a case in which the government had credible arguments, but we all knew that we're very unlikely to win this case. And the nickname for the case was Hawaii 9-0. And we had, my colleague argued that case. And what I watched in the argument, and I think it's been true throughout the time I've been there, is even when you have a difficult case, even a case that you know you're not likely to win, the court gives you a fair shake. They consider your arguments. They think carefully about what you're saying, even though they may not be disposed to rule in your favor. And what you find you can do in these cases is you can affect the rationale and think about the rationale for the next case, how to lose in a way that continues to advance the government's interest in the future case. But what I tell that story because what I say about the court in my experience is I have a great deal of confidence and always have in the court. I never stood up in any of those 56 times when I didn't think that I would that I would be listened to. They may not agree with me, they might give me a hard time, but ultimately it was a fair tribunal. And I think that's been the case as I've been observing the court now for more than 50 years.
I'm trying to think of why I took this this job as a federal judge. I mean, it's a great job, it's an honor, but no one gets rich on this, and it's hard work allocating disappointment to half the people that come in front of you. And if you're a people pleaser, that's not a comfortable fit. But I think I took the job and was excited about it precisely because of arguing in front of the court. Mm-hmm. I really did. I thought it was an incredible legal education, and I was just so kind of blown away by how good and serious the questioning was. I was listening to for reasons that don't make any difference, but listening to the city of Bernie, our oral argument, and just being just so impressed by how good the questions were. I mean, they're just so thoughtful, and every single, across the board. And this is a court that, disappointed me several times and, thought they should have done something else, but there was just no way I could deny they weren't seriously undertaking the job of figuring out what these precedents and what this Constitution or this statute meant. I like your advice about people who are worried about politicization of the court, that they ought to read the opinions first before they draw any conclusions. I might add to that advice, listen to some arguments. You're not going to come away from that experience with the view that these are people that should have red and blue robes. You're going to come away from this experience thinking, wow, they really care about this, they're really listening to each other, they're really listening to the advocates. And, the other thing we know from practicing, and this is not reported maybe as much as it should be, they only take, we should talk about workload later, my thoughts might not be quite as positive, but they only take about 50 to 60 cases a year these days. They're only taking cases that divided the lower courts, so courts like mine. So we take a position that's different from, say, an Atlanta-based court or a San Francisco-based court. So they're only taking cases, for the most part, where people disagreed, like judges who didn't have an agenda disagreed. And yet, I think even last year, at least 50% of the cases are unanimous or lopsided. Mm-hmm. So I think it's, I think last year it's roughly 50%. We're 7-2, 8-1, or 9-0. That's pretty impressive if your 50, 60 cases are all issues that divided the lower courts. And, that proves to me they are, listening to each other, are trying to find common ground, are working as a collegial body as opposed to 9 individuals. So I consider that hopeful as well.
I've got to divert to one thing that you know something more about than I do, and that was the history of Kentucky when it had 2 Supreme Courts. What lessons do we learn from that? Could you tell us a little bit about that?
Do not take the rule of law for granted. It is this story just really astonished me. So a lot of the early disputes in American constitutional history are debtor-creditor fights, often between the lenders, the banks, and the debtors, often farmers, but not exclusively. But that was classically a type of fight you would get that would often lead to constitutional litigation. Impairment of contracts was the classic claim that was brought. And so I think it's 1819, there was an economic crisis, the farmers were underwater. The legislature responds, quite equitably by saying, you can't foreclose within a year and giving the farmers basically some outs. The banks go to the Kentucky courts, they get the legislation invalidated, and it's a little bit like the Rhode Island story where the legislature doesn't like it, but it's worse. The next step is there's something called recall, which is different from impeachment. So a lot of states have something called recall, and recall lets you remove a judge, but it has a high threshold. Usually it takes 2/3 vote by each branch of the legislature. They came up just a little bit short in trying to get rid of these judges. So, Plan B, you just got to love it. Only in America, the Kentucky legislature says, okay, fine, you can't beat them, join them. We're going to create our own Kentucky Supreme Court. So we'll leave the court we don't like. It was technically called the Kentucky Court of Appeals, but think of it as the highest court in Kentucky. They can create a second Kentucky Court of Appeals, same jurisdiction, same state, and talk about forum shopping. You knew just what you were going to get when you went one path or the other. They had, of course, no mechanism for dealing with the inevitable problem that one Kentucky would uphold future legislation, the other would invalidate it, and what do you do now? So this went on for 2 years. So Kentucky has 2 years where they do not have a highest court to resolve the meaning of statutes or constitutions in a final way. And it resolves itself politically, of course, right? So you finally have an election where I think it's the old court folks win eventually. 5 years later, the old court, now the new court, but powerful, invalidates all the new court decisions, which is pretty humorous. But it's a great lesson for judges and citizens, right? It's a lesson for judges that, hey, we're agents of the people, and we don't just put our finger in the wind, but we got to be mindful we have this authority, this delegation, and we've got to be careful how we're exercising it, and legitimacy is quite important. But it's also a great reminder for the people that rule of law, it's a real risk when you go down the road of politicizing courts, because you can very quickly end up with not having a court system. I mean, that is 2 years not having a court system when you have two highest courts that can do the opposite things. So it's really astonishing to me that ever happened in American history, but it did for 2 years in Kentucky, and happily it hasn't happened since. Fingers crossed.
It's a very different story internationally. When early in my tenure with the Chief Justice, we had a very active program with the Russian Judiciary, and we're building bridges with judges there. One of the judges actually came, visited with the Chief Justice, and then went to Arlington Cemetery to lay a wreath at the grave of Chief Justice Rehnquist. They had met each other, and he had found words of encouragement from Rehnquist in terms of improving the Russian judiciary. Flash forward about 10 years, we cannot even find these judges. They have disappeared. You go on, I was trying to Google a few of them. I can't even locate them. I'm sure they're around, but they're now in obscurity, where once they were the leaders of reform. So as Judge Sutton says, we ought not to take our rule of law for granted.
Both of us are a little disadvantaged, but we've watched a lot of this, and some of the polarization seems to be either starts in the nomination confirmation process or it gets reinforced there. And I think one thing that the federal judges as a group, all 1,000 of the lower federal court judges, have not really enjoyed the confirmation process in the last decade or so. And what's really remarkable to me is, we're trying to show as judges that the courts are not politicized, and yet increasingly senators are voting, 100% on partisan lines, whether to approve nominations. So if it's a president opposite their party, it's very hard to get those votes. And of course, it goes in both directions. And the pattern, it's really illustrated by the fact that Scalia was confirmed 98-0 in 86, and Ginsburg in 93, 96-3. I mean, it's unbelievable. For what it's worth, I was 52-41. I mean, that's like going for a D-, and you miss one more, multiple choice question, you don't get any credit. Something's going on there. Now, maybe the elected officials would respond by saying, we judges have created the problem, and they're responding to it by being more intense about who the judges are. I just can't figure. I'm just wondering. I know you're not in a position to resolve this. Maybe you are, but is there anything we can do about it? I mean,
well, first an observation that the confirmation process was routine early in our history. In fact, some judges were confirmed even before they knew that they were nominated. It happened so quickly. One good case is John Quincy Adams was appointed to the Supreme Court. He was busy being ambassador to Russia. And I think they actually had the confirmation vote, and he said he didn't want the job. So it's, but the key point is that confirmation was fairly routine. There were cases, Rutgers is a good example, where someone crosses a line and was not confirmed early in our history. But the current confirmation process, the public confirmation process with hearings really began with the Louis Brandeis. And there was an element of anti-Semitism to that hearing. Mm-hmm. I think that if one goes back, you could see he was opposed both by certain senators, both based on his progressive agenda, but also his progressive practice, I should say. There's been a problem in the confirmation period for a long time, but I think it's become really heightened in the past 15 to 20 years. One thought I have, I'd be interested in your views on this, was the Senate too quick to change the cloture rule, to get rid of filibuster? Should there be, that would force greater agreement, the need for greater agreement among senators, and could also lead to affect a president when he or she is determining who should be appointed, might cause them to be more circumspect in their choices too.
Well, that's a close one. When they eliminated that rule, I was initially happy about it for this basic reason. I did not like nominees having to sit out there, hanging out there. For me, it was 2 years. Mm-hmm. The chief was 2 years at the same time. And one thing that's nice about getting rid of the 60-vote requirement is that now it's a known phenomenon. You're going to have anywhere from 3 to 6 months, and you're either going to get through it or you're not. And so there's a way in which I thought that was helpful. It led to less, really attacking the judges. I feel like there's still some of that, but I feel like there's been less of it now that there's a straight path to the vote. But I quite agree, looking back on how this has worked, that it does have a downside, that there's a whole lot less compromise, a whole lot less common ground. And so maybe in an ironic way, raising the threshold would actually help make it less politicized. You may be right.
I'm not certain. I just put that out as a question because I think that is something that will continue to be debated by historians, if not by members of Congress. Is how did dropping the filibuster rule change the American judiciary?
Well, we have 5 minutes left, so before we take some questions from some of the students, one thing that's been interesting the last 5 years or so, I think it's 5, I'm kind of making it up a little bit, but you've definitely had more cases on the emergency docket, and we see those cases too. So we've seen emergency cases making their way through the lower courts, and then off they go to the Supreme Court. So I can't tell, if this is a national injunction issue, if this is coming from the AGs who now increasingly, one body challenges the president of the opposite party, then the script flips the next administration. But it does seem like there are more of these cases that look like political cases in a lot of ways, and it seems like there are more of them that are demanding a prompt answer from the federal courts, which you can imagine, with my view that the federal court's footprint is probably already too big, that this is not a helpful development. Is there any answer to this? Is this one of those things, again, we have to decide when they bring the case and we judges are stuck? Or is there a way to deal with these cases that, helps, answer the question that's presented in a fair way, but also do it in a way that isn't too precipitous, which makes everyone nervous?
I think there are several elements to this problem. Judge Sutton is politely referring to this as the emergency docket, which is its proper name. It's often described in the press as the shadow docket. And it's described because...
I thought it was the shadowy docket.
But these are cases that come up on emergency motions, and oftentimes they're typically decided on very tight briefing schedules, no oral argument, and usually brief or very or orders, not long opinion. There's not a lengthy opinion that's issued because of the time constraints. One element I think that I've seen from my days in the SG's office is there was a very strong presumption against getting Supreme Court review on matters of the type that have been raised more recently. You simply, in the SG's office, we simply didn't petition oftentimes because we just assumed the court would deny any review. It's very easy for the court to do that on the emergency cases and just let the lower court decision stand. I think what's happened in the past, particularly in the past 10 years, is there have been more emergencies, more matters that require immediate action, and greater reluctance on the court to just let things be when it seems as if there's something that is truly generating conflict in the federal system. The nationwide injunctions is a big part of that. A single judge issues an injunction, and is that one single judge's ruling, if it's appealed, if it's affirmed by a lower court, going to control an important issue of federal policy? I think some of the problems are inevitable. I think to some degree they might be solved by simply just a bit more restraint from the court in acting on these matters, and reestablish the notion that the court is going to give a presumption to the lower courts rather than taking these issues on such short notice with such limited briefing.
Well, one thing I noticed that struck me as a slight middle ground is when I was in practice, I can't think of too many times where an emergency case came and the court, instead of resolving it then, set it for argument in a few weeks, then had argument, and then had a formal opinion. And I'm not sure I want the court to be doing a lot of that, but in a case that really is an emergency, really has high stakes, I've frankly been impressed by the court doing that. That strikes me as a somewhat sensible way to do it. It allows argument, a little more deliberation, usually a more formal opinion. Perhaps I guess your concern is now everybody's going to ask for it. Yeah.
Well, that's happened in cases, but not always with the result that's satisfied the litigants. I mean, Bush v. Gore is a good example, right? Mm-hmm. That was a emergency case. There was a fair argument. The court did not have to get into that matter, but I think there was a sense that there needed to be a final decision from the highest court. But it was very abbreviated briefing, and very oral arguments on a very tight time schedule and a very quick opinion. I don't think that opinion has been cited very often for much of anything. It was a ticket that was good for that day, I think, more than establishing any real precedent. And that's part of the problem with these rush decisions, is that it doesn't get the attention and the deliberation that you ideally like, even with expedited briefing and argument.
Mm-hmm. Well, why don't we shift to these questions, and we're going to take turns. We've each got a couple, so I'll read the question, I'll give an answer, and Jeff, you feel free to add any thoughts. So this first one is from a student from the University of Maryland. Can you discuss how judicial vacancies on the U.S. federal courts affect the ability of the courts to fulfill their constitutional roles and responsibilities? This is a good example of how you can have paralysis, and this is a really serious problem going forward in an era where you have a president of one party and a Senate majority from another. It's really easy to imagine that generating a problem. In fact, in the Sixth Circuit, when I was nominated, we have so the Sixth Circuit covers Michigan, Ohio, Kentucky, Tennessee. There's 16 slots. They're divided among the 4 states based on population primarily. And in the early 2000s, only 8 of the 16 seats had been filled. So that really put stress on the court. And so what this court had to do was they had to bring in a lot of judges from other courts. They brought in district court judges, some from within the circuit, but then they brought court of appeals and district court judges from outside the court. And I think the litigants, I was litigating then, it really wasn't much fun. I mean, you really liked the idea of 16 active judges that you were going to see pretty regularly, being the key writers of the opinions, because you would get to know what they cared about, and it was just a lot more predictable. And so I do think the questioner, raises a really good point. Vacancies are a problem. Now, this goes back to this filibuster point that's so tricky. If the vote is 60, it can be harder to fill. to get the person, although maybe the compromise at the outset makes it easier to fill. But that was an era where it was a 60-vote threshold for cloture. But I will say, I don't think it's eliminated this problem, getting rid of cloture. I'm very worried about an era when you have a president of one party and a Senate controlled by the other. The road we're heading down right now is to not play ball, not find a way to compromise and agree there's a way to have Democrats and Republicans agree that this kind of person would be a good judge on this court. And so the questioner raises a good point. And, let's hope before we face that dynamic, we get a little better at compromise.
I have a question from a student from the Ohio State University. What is the present procedure for removing a judge for failing to meet the standard of good behavior for which a judicial term is guaranteed? Could Congress establish a mode of review and standards for federal court judges? The answer is, of course, the ultimate weapon for removing a judge is impeachment. And of course, the Constitution provides for it. But Congress has enacted a statute called the Conduct and Disability Act. This was enacted in 1980, which provides a procedure for disciplining judges short of impeachment. And the Judicial Conference, the policy-making body of the Judiciary, has created a series of rules to address this. Primarily, it becomes the responsibility in each circuit for the chief judge. And I'm sure that Judge Sutton has seen many claims of misconduct by judges.
Not many, many frivolous ones.
Yes,
okay,
many
fine,
frivolous.
okay.
One of the problems here is many disappointed litigants will say the judge was biased against me. And so the problem is we have a lot of claims that are non-meritorious, and the occasional claims that do merit attention. A chief judge can make a decision whether to dismiss the complaint or whether it should receive further review. If it receives further review, the chief judge appoints a special committee of judges, district judges and circuit judges, to investigate the matter and report back and determine what further action can be taken. And there's a variety of steps that can be taken. It can be a private reprimand, a public reprimand. In some instances, a judge can be removed from cases for a limited period. And ultimately, there can be a recommendation of impeachment. If there's a recommendation of impeachment, it goes to the full Judicial Conference, and the conference determines whether or not to refer this to Congress. So, in fact, there's a statute that regularizes this process and does provide an avenue for review of misconduct of judges. It's not perfect, I think, in some respects. There are other types of misconduct that don't really fit within the notion of the Conduct and Disability Act. And the courts have established their own procedures for other types of employee complaints with regard to harassment or abuse by not only judges, but other people who are in the court system. And this employee dispute resolution process also exists within the judiciary to address those types of complaints. And it has real teeth and real remedies.
No, it does. I mean, happily, it's not very often that you have a judge who's implicated these things in a serious way. But, the federal judges have life tenure, and you have 1,000 of them. There are risks people misbehave, or maybe it's a feature of a disability, or it's a feature of aging. But I think it's a very healthy process to have this in place and try to cut things off before they become problematic. I'm going to save this list of questions because it's really amusing to me. The second question Jeff just read was, listen carefully, student from Ohio State University. No the. Then the next one is student from the University of Michigan. And just never occurred to me, you guys wanted to be like us and emphasize this the thing? I can't tell you how long I've been a little embarrassed by the thing, but sometimes you just got to embrace it. So I'm embracing it. But that is funny. I'm keeping this. This is beautiful.
You did note, if you go back to review the tape, I did see the Ohio State University.
Wait, you're saying no? I thought you kind of understated it though.
I said the Ohio State University.
I know, but you barely said it. We say the Ohio State University. But that means you committed fraud because it wasn't there. There's no there. All right. Well, so the University of Michigan student has a very good question. Why do you think the judicial philosophy of originalism is good for judges to use in deciding cases, and why do you think more liberal, democratic thinkers and jurists have not been as likely to embrace it? This is just such an important question, and I'm so glad to be able to have a chance to answer it. Well, first of all, I think the newspapers, I think sometimes even the legal literature can be a little misleading about this, that originalism is something that only one type of judge practices, and that's really a false dichotomy. I don't think there's been a judge, federal judge ever, and I don't think there's been a U.S. Supreme Court justice that wasn't interested in the history behind the guarantees. I mean, everybody has written opinions about the history of this guarantee or that guarantee. You wouldn't do that if you didn't think it was relevant. So what I think is dangerous about this is creating this impression that somehow history is bad or we don't actually care what it originally meant. That's quite pernicious. I think the reality is that all federal judges do care. They are engaged with the history. And the debate is that some terms in the Constitution, usually some of the more general terms or implied guarantees like separation of powers, where there's not a lot to go on linguistically, that sometimes in those settings, some judges and justices would say either the history's not clear, so I'm not going to let it control the disposition of this case, or even if the history is clear, the term is written in such a general way, say the meaning of unreasonable or the meaning of cruel and unusual, that permits the judge or justice to account for shifting norms over time. And I think if we thought about this in that way, you actually wouldn't have this division. I don't think you'd have Democratic appointees, progressives, being skeptical of originalism. I mean, one of my favorite terms of the court is the year that Jeff Fisher, you know Jeff Fisher, he's a professor at Stanford and a terrific advocate. His first two arguments at the court are this case called Crawford on behalf of a criminal defendant, and I think the other one was maybe I can't remember if it was Apprendi. Anyway, it was a pre-Booker case, but they're both on behalf of criminal defendants. And Jeff Fisher kind of has a progressive orientation in terms of his worldview. I don't think he'd mind my saying that. And in this case, he's representing both criminal defendants. And in both cases, he makes these originalist, historically based arguments for why his clients should win. And he wins both cases. I mean, it's these landmark cases. Scalia writes both of them. He uses the originalist methodology. So it's really dangerous to think it is either or one team versus another. The reality is all judges are interested in this. It can be very helpful to sorting out what to do in a case. And what's really going on is we have some very hard cases with hard areas of con law where there's either a debate about what the history really means or there's a debate about whether that really ought to limit the judges. And that particularly comes through in cases, some of the substantive due process cases that don't turn on enumerated rights where there just aren't as many guardrails. There just isn't as much to go on. So you can imagine why one approach saying I'm not using substantive due process would make a very big difference relative to someone else who would say, well, I'm willing to consider it in some settings. But it doesn't cash out into too many situations where it's truly either or. So, I think this is a way in which Justice Scalia was a victim of his own success. He kind of promoted this and made you think it was affiliated with just Republican appointees or so-called conservative judges or justices, and I don't think that's accurate. I think it did differentiate some cases between, say, him and his very good friend Justice Ginsburg. There were cases, take U.S. versus Virginia, where their methods of interpretation made a difference. But I don't think it was usually a divider the way we've kind of come to think about it. And I think the other thing that might be going on is this debate seems to be most salient, have its highest profile in some of the biggest cases. So, whether it's abortion cases, some of the ones that everybody has an opinion about, it kind of leads to the assumption that this debate about methods of interpretation really is significant in lots of other cases. I don't know, Jeff. I mean, do you think it really drives that many cases? An originalist approach?
Well, I think that Justice Kagan put it, we're all textualists now, and I think the same thing goes to originalism to a certain extent, and that is that you have to look at the initial document first, and oftentimes it will provide the answer. And the question is, what do you do when it doesn't? That's the hard question. But I think any argument before the court always begins with the text, and any constitutional argument is going to begin with what the framers intended at the outset. Where the argument goes from there, I think that's where there can be some divergence. But it certainly has become the starting point in every argument. And I don't think it's identified now with liberals, conservatives. I think it's just become built into the process of adjudication.
And then the hard debate is, what does history show? And if it does show something, do you stop there? Yeah. And not everybody takes the same view of that, but I think everybody's interested in figuring out what the words meant. And the last point I would make, just to try to put it in context, is the reason all judges care about this is, we have a written constitution. Britain had an unwritten constitution. Ours is actually written. We didn't set it to music. We used words. Some of those words were very specific. We all agree that you have to be 35 to be president. There's no debating that. That has a fixed meaning. And it just gets a little harder the more general the language is, which is not shocking. And it gets a little harder with things like separation of powers, where there's not a separation of powers clause. It's implied in setting out Article 1, 2, and 3. And anything that's implied, is going to be a little harder to sort out what the boundaries are. But I think that's really what's driving it. So I guess I have another one from this one from a student from Rutgers. How can the federal courts affect decision-making at the state level? Well, that's easy. Do nothing. If the less the federal courts do, the more there is for state courts to do. But more seriously, I love the fact that we not only have these big American questions, what should be national and what should be local, I love even more that it's ultimately a dialogue, whether you're talking about the legislative branch or the judicial branches, that it really is valuable for the U.S. Supreme Court when it's deciding whether to nationalize this right or that right, to look at opinions of state courts. So state court judges are construing either the federal constitution or similar state constitutional provisions, and that can be super helpful. And sometimes when the federal courts issue a decision, they'll make the point, Smith, there's a free exercise case called Smith, and some people critique it as not enforcing free exercise guarantees as much as the court should. But in the opinion, the court says, listen, we're not saying this is an unimportant value, and we think it's a value the states can enforce through state legislation, creating exemptions for believers, or through state court decisions. And I don't think that's a problem for the the U.S. Supreme Court to say that. In fact, now that I think about it, Justice Kavanaugh has said that in quite a few opinions, where he's joined an opinion which put up a stop sign saying, no, the U.S. Constitution does not apply to this problem, but then either in a majority or in a separate concurrence has explained, but that doesn't say the states can't do this, and don't assume what we're saying about the federal Constitution tells you what you should do under your state constitution, or for that matter, under state legislation, or even a state executive branch order from a governor. So I think there's actually a lot of ways the federal courts, we can both be listening to the states and sometimes explaining that even though we can't provide relief, point out that there's other ways to get relief for people in that position, or sometimes even that exact individual. So I just feel like that's American federalism, and it's had its not so great chapters in American history, see Jim Crow, but it doesn't prove that it's invariably bad. I don't think that's true at all. We don't want to forget Jim Crow and remember the reasons for nationalizing, but there's plenty of pretty heroic stories where the states were the leaders of really good movements, giving women the right to vote. That starts in the western states. There's a lot of really great stories along those lines where we ultimately nationalize things because the states were the first responders and the innovators.
I have the last question for today. It comes from a student from the University of Michigan Law School. How should the bench and bar address the public's decreasing confidence in the federal judiciary? Let me start with the bench. I think in terms of the court's opinions, and this applies to all judges, it's important that the opinions be accessible and that excessive language not be included. It's become more common for language and opinions, I think, to be somewhat strident and aggressive, and that's not helpful. That's what gets quoted by the journalists, and I think it does not reflect well on the judiciary. So I think well-tempered, clear opinions from the bench are helpful. But of course, most people don't read.
What do I do if I have? It's such a good line. It's a little mean, but it's a really good line. What do I do with that?
Tell your wife.
Okay. That has not worked in the past, but I agree with you 100%.
Yeah.
Or write a law review article.
Yeah.
Yeah.
Outside of the court, I think that judges and justices can raise confidence by simply speaking in public settings. And oftentimes it's very effective if judges with different views join in conversations. I think one of the most successful educational efforts were the debates between Justice Breyer and Justice Scalia, where they would appear together and talk about their different views. And they were very engaging, they were funny, and one could not come away without thinking that these are thoughtful people or are acting in good faith and respect one another. And I think that's an important part of confidence in the judiciary. With regard to the bar, I think first, setting a good example, engage in civic education, be good public citizens, be out there talking about the courts, make the court's decisions more accessible. I think all of those things are important. Participate in the many civics programs that are out, that are attempting to educate the public. I think the key to maintaining public confidence is to elevate the discourse above what is easy for the journalists to do, to talk about the conservative judge versus the liberal judge, or to always attach the president who appointed the judge to the decision. You see that all the time. It's always a Obama-appointed judge or a Trump-appointed judge in describing this. And as the Chief Justice said, we don't have Trump and Obama judges. We have judges all doing their level best to try and get to the right answer. And I think elevating the discourse beyond what just fits in, in a byline or in a short article in a newspaper or in a tweet is important to build that confidence.
Well, the thing I agree 100% with all of that, and it's a really important time in American history for lawyers, whether practicing or lawyers who became judges, to be doing the same things. But it's not a bad idea. This is democracy in the 21st century, so I'll mention Democracy in America, which most of you know. And de Tocqueville says a lot of things in there, but I'll bet this is one you might have forgotten. He says lawyers have this really important role in American government, in American democracy, because they understand the rules. He tries to compliment them by saying they're like the aristocracy. I don't think he realized how that would play over time. But he meant it as a compliment, and I think he meant it in a compliment in the sense that lawyers would know that this is within the range of reasonable debate about who's done what and how we should have reform, and this is outside of it. So I do feel lawyers are really well positioned when there's a controversial decision that comes out and, say it's a horrific crime and the alleged murderer is let go, explaining to, fellow citizens, this is how this works. And one price of having criminal procedure constitutional protections is sometimes the guilty go free. But partly that's to make sure the innocent never are punished. And so anyway, lawyers can say that kind of thing because they understand it. And I do feel there is a real role for lawyers today in making us put these intense debates in both current and historical context.
That's a great point on which to end.
Yes, thank you. It is on. Well, I want to thank both of you, Mr. Minear, Judge Sutton, for elevating the discourse, as you just said, for our federal judiciary in the 21st century. Please, everybody here, thank you for coming. To our virtual guests as well, thank you for being here. And again, thank you to both these gentlemen for such a fabulous session.